Welcome, everyone, to our Center for Business Law event, a day in the life of a labor and employment law panel. Um, so I am going to introduce our two panelists. Jeremy Bryant is a UBC law graduate who has been with Bannister and Company since 2017, where he summered and articled. Jeremy has represented clients before various administrative tribunals, including labor arbitrations, the BC Labor Relations Board, the Canada Industrial Relations Board, Employment Standards Branch, and the Workers' Compensation Appeal Tribunal. Norika, and I'm very sorry, you're going to have to remind me how to pronounce your last name. Takacs-Rehm, also a UBC law graduate, is an associate at Roper Grail LLP, where she practices in all areas of employment and labor law with a focus on WorkSafe BC, including compensation and occupational health and safety, as well as general labor matters. So I will keep the introductions short. And kind of the idea here is, and you guys can correct me if I'm wrong, but Jeremy is here kind of representing the employee side of things, or the kind of employee perspective, and then Norika is representing the employer perspective. I imagine your practice is more broad than that. I don't want to caricature what you guys do, but broadly, I think it's fair to say, Jeremy, you represent the employee side more, and Norika represents the employer side more. So we're getting the kind of the two different perspectives on labor and employment law, or workplace law, as we might call it. And so let me mosey over. Uh, Maybe I'll sit in front of you guys so you can see me. And we'll get into our questions. So some of our first questions, these are prepared questions, and some of them are for one of you, some are for the other, some are for both. But I would encourage you, for any question, if it's directed at one of you, the other person, feel free to speak, contribute. There's no we want as much variety and perspectives as possible. So the first question is for Jeremy, but I think both of you would be able to answer this. So Jeremy, on this concept of workplace law, what is, in your view, workplace law, and how is it distinct from labor and employment law?
Okay, so workplace law is kind of a broad term that some people use to describe their practice. And so it actually encompasses both labor and employment law, I would say, but also other areas of law which are kind of tied up in a client's workplace. So that might include human rights law, privacy law, workers' compensation law, which Norika works in a lot. And then also sometimes industry-specific areas of law. So for example, in my practice, I do work that involves the Canada Shipping Act and its regulations, or forest industry legislation. So it can be quite broad. But I'll break down also, just for your sake, the difference between an employment law and labor law, which some of you may already know. So employment law is in a non-unionized workplace, so there's no labor relations between a union and the employer. So you're dealing mostly with individual employment contracts, so things like wrongful dismissals, constructive dismissals, Employment Standards Act matters, that kind of things, as well as the other types of law that I mentioned before. And in terms of employment law, you can kind of practice on both sides. So you can do employee side, which I tend to do more in employment law, but I also do sometimes represent employers, small businesses, that kind of thing. The difference with labor law is that in labor law, you have a union and an employer, and typically you practice on one side or the other. There's more potential for conflicts because it's an adversarial system. So you have an ongoing relationship in the workplace between the union and the employer, and your practice there, if it's before there's a collective agreement in place, or if your client is trying to organize a workplace and bring in a union, then typically you're going to the Labor Relations Board. Also during industrial strife and during labor disputes where there's strikes and lockouts, I'm sure you've seen a lot of them in the news lately, then you're at the Labor Relations Board. And if there is a collective agreement in place, then typically you're going to an arbitrator and dealing with the dispute before a private arbitrator that the parties both agree to. But arbitrators also have broad jurisdiction that the Supreme Court of Canada has given them to consider all employment-related statutes. So you could be dealing with a human rights case or a privacy case in front of an arbitrator.
Norika, would you like to add anything to that? Okay, that was all encompassing. So, Norika, the next question is specifically for you. Um, in your view and experience, is the practice of workplace law primarily a barrister's practice or a solicitor's practice area?
It's both for sure. I was looking at a breakdown of my hours for this year, my advisory work versus litigation, and it's split pretty evenly. So in any given week, I could be drafting submissions for a various tribunal or engaging in mediation or examinations for discovery, more as a litigator would. But I'm also drafting employment contracts and policies and staying up to date on the current privacy legislation or Pay Transparency Act and advising employers about relevant changes to their workplace, more from a risk mitigation perspective, so a solicitor perspective, rather than litigation.
Jeremy, would you like to add anything?
No, I agree. There's a good mix, which is kind of nice sometimes. But you're drafting contracts. Typically, I would say the collective agreement, which is the most important contract in labor background, the parties will deal with it themselves. You don't usually get involved with that, but a lot of work comes out of it because they're sometimes lay people that are drafting the language, so it creates more work for you. But it's just kind of an interesting aspect of labor law.
Interesting. Does the practice of workplace law look different depending on what type of firm or legal work environment you practice in? I imagine the answer is yes, but Jeremy, could you maybe explain how?
Yeah, for sure. So I think as the description of the event explains that a lot of full service business firms will have labor or employment practice groups, and then you also have firms in terms of labor that practice on the union side or the employer side. I'd say they're boutique-ish. Some of them are quite large. Norika works at one of the larger employer side firms. I work at a very small union side firm. So currently there's only me and my boss, Bannister and Company. I guess I'm the company. And the work really can differ. So if you're part of a larger employment group, you can specialize in different areas. So for example, I work sometimes opposite a lawyer at Lawson Lundell that like kind of just specializes in privacy and data management for clients. So he's got kind of a very specialized practice. Also, some lawyers will focus on a specific industry. So you might have somebody that works a lot with employers on healthcare or education. You could have the same, I suppose, on the union side. Whereas a small firm, you kind of get to touch a bit of everything, as I have. So different industries and different files. Also, there are in-house counsel. So for some of the unions, mostly in the public sector, like the BC government, they're called I'm going to get the name wrong, BCGEU, I'll just use the acronym. They have quite a large legal department, Health Employees Union, CUPE, BC Teachers Federation, and then also some of the private sector unions on the union side. And I expect there's the same on the employer side. In healthcare, there's the Health Employers Association of BC, and there's others that are kind of focused on different industries. So yeah, there's a lot of different
Okay.
areas.
Kind of dovetailing on that question, Norika, as someone who is representing the employer side more often, what type of individuals and organizations are typically your clients?
Everything from employers who have 10 employees to the biggest employers in the province. So Depending on what I'm working on, like I do a lot of occupational health and safety for some of the bigger employers in the province. They tend to have broader, more comprehensive safety programs. So that's why we're usually assisting them, as well as bigger risks associated with their industry. But some of my most consistent clients are smaller employers that are just working through the basics of ensuring regulatory compliance, but also keeping their employees happy as well.
Okay, so the remaining questions that we have prepared are kind of open-ended and that both or either of you can answer. So just, take turns, figure it out among yourselves. But I'd like to hear from both of you on the following questions. So I guess the first is truly on the theme of day in the life. What is a typical day like for someone practicing workplace law? Like, what is your typical day to day, if there is such a thing?
I would say no such thing. Every day I go into the office with a plan and then everything changes pretty much from the moment I get to my desk. But I was just looking at my calendar for this week to see what types of tasks I was working on. So I've drafted an investigation report for a bullying and harassment complaint. I prepared submissions for the Workers' Compensation Appeal Tribunal about whether a mental disorder claim should be accepted. I've drafted an accommodation policy for an employee who we're not quite sure is demonstrating culpable or non-culpable conduct. I also attended a session yesterday for employers across the province discussing upcoming changes to psychological health and safety regulations out of WorkSafe BC. So it was just a chance to get on the ground and speak with the board about concerns and violence and harassment policies. And today I'm here. So it's different every day.
I'd really echo that diversity. I thought about it in terms of kind of the general work that I would do. So, well, earlier in my career as an associate, I had more of a supportive role, whereas now I do more client interaction and kind of strategic advice, especially for the unions that are our main clients, and also kind of handling more of the arbitrations and the litigation side of things on my own. So that involves a lot of file management, case management calls with arbitrators and the lawyers on the other side, settlement negotiations with the opposing counsel. And then like in terms of the types of matters that I've dealt with in the last month or so, I've had labor arbitrations for an employee who was terminated for sending inappropriate emails in the workplace. I have an arbitration on employees that were excluded from the union's bargaining unit because the employer said they were acting in a confidential capacity with respect to labor relations. So there's concern about a conflict of interest between being in the union or and your kind of duty to the employer. I've had contract interpretation cases on seniority issues. We've had matters before the Labor Relations Board where dealing with good faith bargaining, the requirement to bargain in good faith, an allegedly illegal strike, certification applications, duty of fair representation complaints by employees against their union, so we would represent the union, essential service levels for a union that is going to get on strike, where the employer says that you have to maintain a certain level of service to kind of protect the health, safety, and welfare of British Columbians. Also WorkSafe appeals at the WCAT. I've been dealing with a judicial review in the courts over an appeal of an arbitration decision. And that's just a few examples that I can think of from the last month or so. So, I mean, I think we'll get into it in some of the later questions, but I really enjoy that diversity. Although it does require you to kind of keep updated on a lot of different areas of law.
Yeah, thank you. So just to interject a bit, we had another event earlier this week where we had a day in the life of a corporate lawyer, and we had two lawyers who focus on M&A and securities. And I asked them, what is a typical day in the life of a corporate lawyer? And they were both like, "There's no such thing." And like, you have a list of everything you want to done in the day, and then you go to work and a million other things come up. So I think that's just kind of a constant theme in the legal profession is it's never boring and you have unexpected work coming up all the time. Okay, so moving on to the next question, a bit more of a personal question. How did you decide to practice workplace law, and what do you particularly like about this area of practice?
So I started my practice in insurance defense at a mid-sized firm. It was great. The lawyers were great. Most of the work was enjoyable. But once I started to build relationships with adjusters, they would send me files on topics that I just was not interested in. And with a lot of defense cases, you have thousands of documents. It's multi-party litigation. It spans for years, and I just wasn't enjoying it. But I knew that I didn't want to leave private practice. So just by chance, I had one. It's called a prohibited action complaint. It arises out of the Workers' Compensation Act, and it just so happened that one insurance policy covered the mediation for this prohibited action complaint, and so they sent me, and I loved it. I thought it was so interesting, just the personal dynamics, the mediation process. And Roper Grail had a posting on the CBA, and I thought, oh, okay, it looks like they do labor and employment. And I applied, and I guess it's been 3 years now. One thing about litigation is you're always on the back end. You're 2 to 5 years out from the event, and there's nothing you can do to change what happened. But what I really like about my practice is it's more of a risk mitigation practice. I can work with employers to prevent incidents. I can work with employers to develop safety programs. And so I like having that kind of influence and expertise with my clients. And it is never boring. Every day is really interesting.
Yeah, so for me, when I came here to UBC to law school, I kind of expected I would end up practicing labor law. Well, I came in with an open mind because I had come from being a provincial first vice president of a union, of the BC Ferry and Marine Workers Union. So I really kind of enjoyed labor relations, and I wanted to get into law because of that. But also, I would say it kind of aligns with my values, because I think that labor law and the labor relations system and the institutions that surround it are important to kind of balance society and provide equality, and kind of help support like liberal democracies. So I think it kind of balanced with my values, and I think that on both sides of the labor bar, you kind of get that sense that we're trying to uphold the labor law system, and as I said, kind of the ongoing relationship between unions and employers. On an individual level, I kind of echo what Norika says in terms of being able to see the impact of your work. So, for me, it's obviously rewarding if I'm able to get somebody their union job back, if they've been terminated and termination was unjust, or have them provided benefits if they were denied, that kind of thing. I also really enjoy the diversity of the work, which I've already talked about.
Okay, so it was great to hear about what you guys like most about your job. Now let's turn to a more negative note. What are the things that you don't like about your practice area?
I don't like when my clients don't listen to me and I've told them to do something and then they call me on a Friday and say, we did the exact opposite of what you did and now we're being sued. Okay, well, I find that rather annoying because you're still dealing with people all the time. And it's still private practice. Days can be long, days can be stressful when you get your strike notification from a union and you have 72 hours or however long to get your list together. And now you're at the labor board and you had all this time set aside for all this other work. But that's just general practice. I think that's with being a lawyer in any practice area. But other than that, I mean, I think everyone has their files that aren't their favorite, either because of the subject matter, or you just can't get documents, or it's just moving along really slowly. But I can honestly say that I really enjoy my job.
Yeah, I kind of echo it again. Just I don't think these are unique to workplace law practice, but and one thing maybe that's kind of a little not necessarily unique, but you have, as I've said like repeatedly, kind of there's an ongoing relationship if you have a union and employer, and on one day you might be at each other's throats in an adversarial process, and then the next day you're back in a labor management meeting or you're across the table in collective bargaining. It kind of gets exacerbated in that you have the same players. So if you have somebody that's really unreasonable or takes unrealistic positions on either side, then you kind of have to manage that. Just the human element of practice, which can be a challenge. And I do like the pragmatic aspect of labor relations, where you're trying to get to a solution. You're trying maybe not necessarily to win in kind of like a zero-sum game case, because you realize that you're trying to make labor relations go smoothly down the road. So it can be really frustrating when you have, a pragmatic idea and either your client or the other side doesn't see that, even though it's out there to grasp. And arbitrators and mediators, they can get involved and try to help the parties come together, but it can be a challenge. But other than that, yeah, I really enjoy this area of practice as well.
What is the single most interesting matter that you've worked on so far in your career, if you could name one?
So about once a year, I tend to get involved in multi-month investigations. So a few years ago, it was about an 8-month investigation, and it was involving allegations of time theft across the whole department of an organization. And yeah, I think from start to finish, it was about 8 months. There was 10,000 documents, there was 50 interviews, and we practically lived at this place, me and this other investigator, because we just had so many people that we were interviewing and investigating. And that sort of led on to this is a very unique opportunity, and it probably won't happen again for me, but I was temporarily called in Nunavut last year, and a colleague and myself, we were conducting a workplace environmental scan, so a temperature check of an organization at a remote mine site in northern Canada. We were up there for, I think it was 32 days total, 180 hours of interviews, 200,000 pages of documents, back and forth in these tiny little planes to Nunavut and Yellowknife. And the ultimate report that we produced was about, I don't know, 300 pages. And it was just from start to finish, just so interesting. Things came up all the time, ethical questions, weather delays. We saw a grizzly bear. Like it was really, really cool.
Yeah, it's hard to pick just one, but I guess the one that I thought about in preparing and is a labor dispute, and those can often be the ones that throw your days sideways, as we've discussed. But we had one where in 2022, my boss was away on vacation. My client was the Canadian Merchant Service Guild that represents ships officers on tugboats in Vancouver Harbor and in the river. And they hadn't been on strike in something like 30 or 40 years. So they were looking where they could establish a picket line, because at first they had set it up on their employer's property, on C-SPAN's property. This is all in the public record now, so I can talk about it. So we were looking, they're under federal jurisdiction, shipping, and so the rules are different than in BC, where picketing is much more restricted, and the BC Labor Relations Board can restrict picketing. So we were kind of in this interesting loophole where they set up a picket line, and I was looking at municipal maps and figuring out where the public land was where they could stand, as opposed to being on private property, so they weren't trespassing. And they were kind of inhibited, like the picket line was in such a place that provincially regulated workers were refusing to cross it. So they were basically shutting down Vancouver shipyards at the same time. So we had court injunctions over that, which we were successful on. And then they were asking about whether they could set up water pickets in Vancouver Harbor with cruise ships. So, I mean, we're dealing with like huge liability, case law between federal and provincial jurisdiction over picketing, what type of behavior could be enjoined by the courts or by the Canada Industrial Relations Board, what the BC board would touch and what it wouldn't touch. So like multiple applications going on at the same time. But in the back of your mind, you're like, well, how can I help my client maximize the economic pressure that they're putting on the employer? The idea being that this labor dispute comes to an end quickly, because you don't really want that. You want to get to a collective agreement, but also dealing with all kinds of interesting legal issues, and then sub issues at bargaining. So there was, is this bargaining proposal legal or not? And then there's charter rights at issue, whether you can, because you have a right to strike under freedom of association. The right to picket is under the right of free expression, but balanced against the economic interests at play. So I look back and it's kind of a blur, but I think of all the interesting issue, and I guess I don't know if it stands out just because it was so traumatic, because I was dealing with all these things on my own, but it's definitely one of the ones that stands out.
Okay. Yeah. So it sounds like the best and also the worst.
Yeah.
Okay, so what types of careers are available to lawyers who work in workplace law generally? Could you guys maybe kind of survey the different career paths within the field of workplace law?
So I guess the obvious one is counsel, either in private practice, and again, you have to choose between union side or employer side, or you could be in-house counsel. Then there's a lot of opportunities to be a decision maker, whether you're working at an administrative tribunal. I was appointed last August to the Employment Standards Tribunal, which I just do off the side of my desk, but I write appeals of employment standards branch decisions. I consider appeals, I should say. Or you can work at the Labor Relations Board, the Human Rights Tribunal, that kind of thing. Some lawyers will eventually become arbitrators and decision makers. Typically, you go to the Labor Relations Board first, and then you can hang up your shingle, they call it, where you advertise your arbitration practice. And if you develop a good reputation, then both sides can agree to you as an arbitrator. And you kind of work as an arbitrator and mediator as well. Many judges also come from workplace law area. You can be just a mediator. I think you're seeing that a bit more. So some of the tribunals will just have mediators that have a legal background. And then also another one I thought of is a workplace investigator, and Norika can probably speak to that more, but I know there's a particular firm, Southern Butler Price, that kind of their specialty is to go in and do workplace investigations.
Yeah, I don't really have anything to add other than, just on the investigation piece. There are quite a few lawyers at our firm that do practice in investigations or workplace scans. I'm one of those lawyers. That's everything from conflict of interest, time theft, bullying and harassment, discrimination. As part of my occupational health and safety background, I also do incident and fatality investigations as well. But other than that, I mean, I think you've covered them all.
Okay. So final prepared question. What advice would you give to law students who are interested in practicing workplace law?
So again, my experience coming into labor and employment or workplace law was unique in that I started at an insurance defense firm. And I actually think for me, that was the best decision because I was given a lot of autonomy and a lot of oversight over my own files. As a 2-week call, I was counsel of record for BC Supreme Court files. I was managing multi-million-dollar litigation. I was going to mediations as a junior with counsel 30 years my senior. And that, I think, gave me the skill set and a transferable skill set to be successful in labor and employment. And so it really is, for me, just about developing your skill set, figuring out what you like. I really like drafting submissions and investigation reports, so I focus on that. When you're more junior, I think you just have to be open to everything. I mean, when I first came to this firm, I didn't say no to any type of work. But now if a privacy file comes to me, I shuffle it off to someone else because I know that that's probably not the best file for me, but I was open to it. So I think just being open.
Yeah, I think it's similar to a lot of other areas. It's useful to soak up what you can during your education. So, I mean, the courses that were available when I was here included employment law, labor law, administrative law, human rights law, and there may be others. Also, I mean, I still use, my business organizations and contracts. All of those are very like fundamental, of course. Career services offices is great. It can help. It. I know even when I kind of already had an avenue when I was here in terms of connection with the small firm, which I've been at since I was a summer student after first year. But they helped with things like, negotiating my first contract and that kind of a thing. We also started a labor law club. I don't know if there's any active, but we did a firm tour, so you can kind of explore the options. One like practical tip is the labor relation, if you're really interested in this area, and you're not just here for the pizza, which I don't blame you because I did that sometimes, is the Labor Relations Board on their website. They have a mailing list, and they just set that up a couple of years ago. So they send out career opportunities, networking events, and updates from the community, being like the employer and union side labor bar. And I know there has been discussion. I know this because I'm friends with the current chair about maybe getting articled students at the labor board, which would be a really awesome opportunity. What else? Oh, the CBA has a labor law section. Specifically on the union side, they often look for experience in social justice issues or human rights issues. But even if you are able to volunteer at LSLAP, working on those work safe type files or employment law type files, that's always a plus. But also, I mean, I guess if you're trying to like kind of present yourself when you're applying for those types of jobs, think about the work experience that you may have had if you get a chance, because those, like, I still harken back to my time working on BC ferries where I was just kind of like emptying garbages and stuff in the cafeteria, but I understood how the work processes worked, what kind of marine transportation tickets you would need to become an officer and a captain and that kind of thing, and they're still useful for my work today. So yeah, those are some things I thought about. Also, you can ask to go for a cup of coffee with a lawyer, and I'm always happy to do that. So.
All right. Thank you very much. So that is our prepared questions, and we've got plenty of time for student questions. So I would like to turn it over to people in the audience. I guess you guys can field your own questions, but anyone who's asking a question, I would just ask you to use your desk mic so it gets picked up for the online audience.
Yeah, so my question is whether, I guess, when you have clients who are small to medium-sized businesses as opposed to large corporations, how does the work differ? Like, what kind of work is there for those types of companies as opposed to larger ones?
For me, when I'm coming into a small business, usually the first task is just a checklist. I find that a lot of smaller employers don't actually know what they're supposed to have in place. So it's kind of starting from the bottom of like, do you have the appropriate occupational health and safety legislation? Are you compliant with the ESA? Do you have the policies that you're required? Are you compliant with the Employment Standards Act? Vacation pay requirements. So it's a lot of just, okay, what is here? What are you missing and how do we get there? So it's a lot of, we call it hand holding, just a lot of guidance. And The work is more, I find, on the fly because they don't always have the expertise and experience or in-house LR, labor relations or HR, to be able to manage like investigations or performance management on their own. So they're often calling us for, before issuing discipline, whereas a big employer or a larger employer would have those processes in place already and probably have the training in place as well. That's the biggest difference that I've experienced.
Yeah, the only thing I would add is because I've only done a little bit of work on the employment side, as I said, representing employers, and you're right, they can be less sophisticated because they don't have HR departments necessarily, and they don't have that knowledge. So it's a balance of, trying to educate them and trying, for me, it was, and trying to provide kind of cost-effective options as well. Like give them the option, but explain, well, you might want to, resolve this rather than litigate it. Whereas more sophisticated, larger organization might already have kind of that institutional knowledge built in. So. What's next?
I just had a question, like working for like a larger firm, do you find yourself working for like, or working with individuals in a specific workplace, like employees or like between individuals at all? Or is it kind of just like a more larger scale working for like being a company's employment labor? Or like if there's a dispute between two employees, like I don't know, like a harassment case, for example, would you be working with like individual employees of larger companies? Yes, that makes sense.
So most of my direct client contacts are either a manager or head of HR or labor relations. So as an employment side lawyer, we're acting as for management essentially. I do also do pro bono work, and in that work, I act for the employee, which can be challenging because we're conflicted out of a lot of files. But that's where I get the more plaintiff side employment work.
My question was, throughout your career, have you noticed that there's been kind of a concentrated industry that you work within employment law, or is it kind of one stretch of months there'll be one area of BC industry, another one will be somewhere else? And is there the option to specialize as an employment lawyer within, say, maritime industries or something like that?
For me, I think it comes in waves. So I'll do a file. So 2 years ago, I did a file for in the forestry industry at the Labor Board. That went well. So then there was more calls from the same management, and so I found myself working in the forestry industry. But I also do a lot of work with school districts or municipalities. Like I said, I tend to work with the larger employers in the province. And what's really nice about working for a specific industry is you get to know the players, you get to know the labor relations if there's a union, and you get to gain really technical knowledge, which I really enjoy because I love learning. So I'll get to, if I'm working with a utilities company, I'll get to know all about physics and electricity and work really closely with experts in that subject area. And I'd say you can, there are lawyers at my firm that do just work for particular industries that they really enjoy. So I think that option is there.
Yeah, same on the union side. It's similar. Unions will typically represent in specific industries. So some of our largest clients are the steelworkers local that came out of the IWA, which does forestry. So we do a lot of forestry. So then we have to learn about what a forestry operation looks like in the bush, as they call it. So from where you're falling the trees to hauling them to like, forget some of the terms, but you learn all the different terms, which is really, really interesting. And then in the sawmills as well. So forest industry, marine industry, we do a lot of work as well, like I've already kind of touched on. And then we do some work for the union that represents the employees at BC, a certain set of employees at BC Hydro. So then you're learning about the electrical trade a little bit and stuff like that. So there is definitely an opportunity. And on the union side, it kind of, because the unions are your clients, you're going to get work based on whichever unions you're representing.
Yeah, so like in the news lately, it seems like there's a lot of like questions of constitutional law and how they apply to labor disputes, like around like Section 107 or like use of the notwithstanding clause. I'm just curious if either of you have been kind of involved in that in your workplace.
I haven't directly. I remember when I was in law school, there was the big Saskatchewan Federation of Labor case, and I knew the lawyer who had argued it at the Supreme Court of Canada. So you do have those kinds of opportunities, but it kind of maybe you have more opportunity if you're at a bigger firm, at a small firm like mine. It's just when they come up, and oftentimes you're just arguing charter values should be applied by the administrative tribunal, whether it's at an arbitration or whether it's at the Labor Relations Board. But certainly those opportunities do arise, and sometimes you have kind of the umbrella labor groups. So in that case, the Federation of Labor, where they may hire counsel from one of the more reputable or larger firms or a smaller firm to represent them in charter challenges. So, but it does touch our practice. It just kind of depends, like in a small firm, whether, kind of comes across your desk or not.
Yeah, the same at a bigger firm. Charter values are argued in quite a lot of cases, so you will touch on it. But I know there are lawyers at our firm who handle some of the bigger labor relations files that have dealt with constitutional issues, either in the courts or in front of an arbitrator.
Can you hear me okay?
Yeah.
Okay. Thank you both for coming to speak with us. This has been really helpful and giving some insight into your industry. I have two questions. So the first question I have is pertaining to your response about how you worked in none of it. I just wonder how much of your work involves field work, if you were to give it a percentage. And the second question I have is, as junior lawyers, can you speak to more of what kind of skill set we should be looking to acquire getting started to give ourselves the best chance at like being qualified once we step into more of a specialized role? Thank you.
And just by field work, what do you mean by?
I guess, not in the office building,
Okay.
somewhere, working directly with your clients.
Yeah. So I try to get out, especially if it's a new client and I don't know the workplace or the industry, I make an effort to go out into the field, understand the workplace. It's really important for occupational health and safety in particular when we're making policies. If I don't know what the floor of the factory or the sawmill looks like, it's really hard to understand how those procedures are going to apply moving forward with employees. Same with investigations, especially scans. I generally insist that those be in person because for me, understanding the dynamics with the individuals that I'm speaking with, how they interact in their workplace, it's essential for making findings of fact and credibility analysis. So I spend a decent amount of time out of the office with employers, more so than I did in my previous practice or my previous role, as well as with mediations and hearings. Those are generally, at least in my experience, in person as well, which is great.
Yeah. So what my understanding is that from my boss is that it used to be you'd be in small towns all over BC for hearings, but since COVID and people have gotten more comfortable with video conferencing technology, a lot of hearings are done remotely now, so you don't get out of the office as much. But lawyers that have practiced for a while have more war stories, and I'm kind of jealous of your experience of going up to none of it because I spend more time in the office than I'd like. But you do get the opportunity, and now some of our clients prefer to have in-person hearings and mediations and have that face to face. Do you remember what the second question was? Oh, the skill set. So early on, I would say legal research and writing, which doesn't sound exciting. I personally actually really enjoy that. But as a younger associate, summary student, articling student, I did a lot of that, just preparing legal briefs and legal memos for the more senior associates and for the partners.
I think what served me well at this firm in particular is being really open and quite forceful about seeking feedback from my peers and others that I'm working with. And not being afraid of when I get a paper back and it's all red because it's all wrong. I've found that that's developed the structure of my submissions. It's helped me just be more resilient when things don't go my way, whether that's with an arbitrator or with a client, because I don't take the feedback personally, and so I think that's one skill for me that's really served me for learning and developing in my career. Definitely agree with legal research and writing. At first, it can be quite tedious, but I also really enjoy it. And it's important for every area of law, no matter what your practice area is. And just developing, for me, like being organized, so developing like time management and organizational structures, that'll serve you well. And it's not specifically legal, but you spend so much time rearranging your schedule and thinking of deadlines. Like if you can have systems in place before you even start the work, you take a lot of that brain work off the everyday agenda.
I was just wondering. How it is working in sort of like a mediation arbitration environment, like compared to, how the adversarial system actually works. Like, what are some of the, I don't know if because you mentioned you work in insurance defense. I don't know, how would you compare like a
Yeah, I found that very confusing when I first transferred over because the civil system is an adversarial process. And I remember I had an arbitration maybe a month after I started. I was junioring, and we picked the arbitrator together with the union, which just seems so strange that you're like, no, I don't want that arbitrator. We want this one instead. I thought that was so weird. And it was it was quite informal as compared to the civil process. So you still have your openings, you still have your direct, but I think we missed exchanging what's called particulars by a day, and I was so worried about it. And no one cared. It was just like, oh, we'll just give it to them on Monday. It's fine. We'll just give them a heads up. So the informality, I was uncomfortable with it at first, but it is nice to not be held to the Supreme Court civil rules. And then in terms of WCAT or the workers' compensation, that's an inquiry system. So that's an even different system than adversarial, where the goal is to just get to the truth essentially of whether there's been compensable injury arising out of the course of employment. So that's a whole different approach and perspective as well.
Yeah, I would just add that, like I've said multiple times, you have kind of the background of the ongoing relationship as well. So sometimes, or I should say arbitrators have kind of a duty under the labor code as well to act as sort of mediators to try to explore settlement. So sometimes you go in, you do all your preparation, you go in ready to litigate, and then the arbitrator pulls both lawyers out into the hall and says, why are you guys litigating this kind of thing? And that's normal. Or I had a hearing last week where I knew we weren't going to be successful, but my client was insisting that I take this matter forward. And part of the main issue was the griever, because they couldn't get him on board and realized that there was no chance he was going to get his job back. And so what the arbitrator did, and he had a bit of a hard time understanding it, because of course you want the decision maker to be neutral, but he did it in a good way, where he kind of chewed me out, and he said, in front of the client and in front of the griever, Mr. Bryant, if you could find me one single case where an employee sends an email that, after he's already been given a 5-day suspension, a 10-day suspension, a 15-day suspension, and then he was terminated, and then he sends an email to his boss and tells him to F off and more, which I'll leave out, and gets reinstated, if you could find me that case, do it. And I said, I'm sorry, Mr. Arbitrator. I know no such case exists, but that's what we needed to get the griever on board and resolve the matter for the parties. So.
I know it probably varies quite considerably between organizations, but can you speak a little to work-life balance, kind of the expectations of that? Again, I think it comes to down to private practice. You know, you do have your billable target, you do have deadlines and expectations. But I think it is what you make it. I know that sounds like a cop-out, but as an example, last year I did not have work-life balance. I worked. And I didn't feel very good at the end of the year. And so I reassessed and I thought, okay, I really enjoy this. I want to do private practice for the rest of my career. What can I do? So I signed up for an ultra marathon because I'm like, okay, if I'm training for that, then I can't work these hours. And it worked really well. And being in private practice, it's unique in that I set my own schedule, I set my own hours. As long as I don't have meetings, I can, you know, be where I want when I want, as long as I'm hitting target. And though I will say I'm a 6-year call now, and I wouldn't have been able to do that as a 4 or 3-year call because you just don't have the knowledge of how to set that up. You need to be more available. So I think it comes over time. And I was really intentional about the first few years in an articling about being available for my firm, and that's worked out really well for me.
Yeah, like any area of law, it can be a challenge, especially in private practice. Some lawyers around like my area of call, I guess, coming on 8 to 10 years, they might go into private practice just so that, or sorry, into in-house so they have a bit more of that balance. For myself, I started law school right when my 4th child was born, me and my wife. So, you know, it's always been kind of a necessity that I have that work-life balance. And I think Norika's right that you can kind of set your own boundaries as best you can, and hopefully your firm, I mean, you practice in the area of workplace law, your firm should be cognizant of it, but it certainly can be a challenge. I guess what I've found helps, and it's another thing that you mentioned, which is just time management and being really deliberate about your time. So for me, it's like finding what works. I'm more productive if I'm working in the office than if I'm working from home. And if I'm, you know, if I have the systems in place where I'm really just focusing on getting the billable targets done, then it's easier.
Any other questions? Any questions online? All right. Well, that was a very robust set of questions. So thank you to the students. And thank you very much to Jeremy and Norika for coming in and talking to us. I really appreciate it. Yeah. And thanks again, everybody. Great event.